people.
I hit the record button.
All right.
We are recording.
All right. Good morning, everyone. Good morning. Hi, everyone. My name is Michelle Socker. I am the Director of Sponsorships and Special Events here at the Chamber of Commerce of the Palm Beaches. And today, you guys, as our guests, are in for a very interesting and engaging webinar about protecting your confidential business data and people from unfair competition. I would like to do a couple things and share with you what's going to happen today. First, we're going to talk about just briefly best practices for Zoom so the meeting goes well for all of us. And then second, I'm going to introduce our three speakers from FordHarrison law firm. And then I'm going to hand it over to them and we'll get the webinar underway. Oh, I missed one thing. Before I hand it over to them, after I introduce our speakers, we're going to give each person a chance to introduce yourself so that David, Matt, and Ari know who's in the room. So if you could share with everyone your name, your role in your organization, your title, and your organization name, that would be very much appreciated. So let's start with Zoom best practices. So for today, if you are not speaking, we ask that you are on camera, if that's convenient for you to stay on camera so we can get to know you and see you during the webinar. It helps the speakers be able to see people's reactions, of course, and things like that. And also, David, Matt, and Ari have asked and are hoping that this is a very interactive webinar today. And so they're hoping that there will be some good questions. And so please, absolutely, if you have a question, we're going to invite you to unmute yourself and, you know, either raise your hand like this or put your little hand up on your screen. Of course, you can, and we'll call on you. The speaker will call on you and definitely is interested in your particular questions. So we do welcome that. All right. So that's it for Zoom best practices. I would say if you're not speaking, just again, keep yourself on mute because sometimes there's background noise that you think is not that loud, but it could come across on a microphone as louder and a little bit disruptive to our speakers. So please do keep yourself muted until you have a question or we're asking you to introduce yourself. All right. So with that said, I actually am going to switch something. Kelly, are you able to see all of our participants? Okay, can you unmute yourself and call on each person and if they could introduce themselves?
Certainly.
Okay, I can't see.
Okay, good morning. Robert, would you like to introduce yourself to the group, please?
Absolutely. Hold on, I'm having some trouble with my video. Here we go. My name's Robert Wagner. I'm the Executive Vice President with Health Max Center here in Palm Beach Gardens. Also an ambassador with the Chamber of Commerce, and really excited to hear about the information today.
Excellent. Thank you so much for joining us. Stanley, would you like to introduce yourself?
Yes, good morning. Let me open my video as well. My name's Stan Labovitz, and I'm the CEO of two companies. One is called Survey Intelligence, and the other is Predixa. And we're in the business of consulting and providing leaders with knowledge to effectively run their organization through our diagnostics. So,
Excellent. Thank you. Thank you again for joining us.
of course,
And we
thank
have
you.
somebody who's just connecting in. Oh, there we go. Jonathan, good morning. Thank you very much for joining us. Would you like to introduce yourself and tell us quickly what you do? We'll give him a second, see if he can unmute himself. In the meantime, Kirby, could you just introduce yourself quickly so we know who the heck you are?
Absolutely. My name is Kirby Davis, and I am the Membership Services Associate for the Chamber of Commerce of the Palm Beaches.
Excellent. Thank you, Kirby. Jonathan, there we go. Jonathan, can you introduce yourself? Thanks for joining us.
Oh, hey, good morning. Yes, a new member of the Chamber. I'm here representing Spinnaker Group. We're a green building consulting company here in West Palm Beach.
Excellent. Thank you very much for joining us this morning. I see we have one other Chamber of Commerce entry here in this room. Kirby, are you coming in by phone twice or?
Nope, I should just be on here once.
Okay, all right. Whoever that is, would you like to introduce yourself? Okay. All right. Michelle, I think we'll turn it back over to you and you can introduce our speakers.
Great. All right. Thank you. Thank you, Kelly. And all right, so our speakers today, first we have Ari Hernandez. She is a counsel with FordHarrison. She received her JD from the University of Florida and her undergraduate degree from Florida International University with high honors and Phi Beta Kappa. She devotes her practice to helping employees navigate litigation, investigations, and day-to-day employment issues. She was named a Rising Star by Super Lawyers Magazine for business litigation in 2010, prior to becoming in-house counsel for 2 engineering companies with multi-state operations. So welcome, Ari. All right. We also have our second speaker is Matt Luttinger, who's an associate of FordHarrison, and his practice focuses primarily on litigation and compliance. He received his JD from the University of Miami with honors and undergraduate degree from Florida State University. While in law school, he served as the articles and content editor for the University of Miami International and Comparative Law Review. All right. And David Gobeo is a partner, our third speaker, of FordHarrison, who focuses primarily on litigation. David received his JD from the University of Florida and undergraduate degree from Stetson University with honors. He's a member of the Forum Club of the Palm Beaches, the Palm Beach County Bar Association, and has been an active member of the Associated Builders and Contractors for his entire career. He's also a member of our Chamber of Commerce of the Palm Beaches here today, and he is a board member. And so Kelly and I have had the privilege of getting to know David and working with him over the years, and he's an active board member and does webinars like this as in a leadership role here at our own chamber, and we thank him for that. He's been named a Rising Star by Super Lawyers Magazine from 2012 to 2019. All right, so welcome Ari, Matt, and David. I'm going to ask you guys to take it away.
Thank you, Michelle. Yeah, and I know what everybody's thinking. What kind of lawyers are these? They don't even look like cats. Well, I'm not a cat. And I apologize for my voice. I actually lost it last week completely, and it's coming back now. But I promise the substance of what we're presenting will far outweigh the manner in which we're presenting it. As always with our presentations, we'd like your participation. So like Michelle said, feel free to just interrupt. You can unmute and go ahead and ask the question. If you feel more comfortable putting in a chat box, that's fine too. Remember, put it in the form of a hypothetical. You want to make sure you maintain your attorney-client privilege. So say I have a friend that, or hypothetically speaking, so we can make sure. And everybody is going to get these slides. So that'll have a lot of the substantive information, the basics. So don't feel like you're slowing us down by asking a question, because really discussing these issues is what will help you understand how the law works and how it applies to your business. And normally, the attorneys at FordHarrison, we say we're employment defense attorneys. So that means we're defendants in lawsuits. We only represent management and businesses in employment disputes. But in these particular circumstances with non-compete type of cases, we can actually be the plaintiff in a lawsuit. What will happen is we will sue a defecting employee who has stolen trade secrets. And on some occasions, we'll defend an individual person who's starting their own business and the former business is saying that they're competing. And this is an area that we have a lot of experience in. And so we want to run through how the statutory framework applies, what kind of agreements you can have for your business, and how best to protect your business assets. So Michelle, if you want to go to the next slide. So we refer to these agreements as restrictive covenants. And there's a number of different kinds of restrictive covenants. Sometimes you can incorporate it all in one agreement, or sometimes you'll split it out and only have part of it. So a non-compete, a strict non-competition agreement is one component. You can also have non-solicitation agreements, and they can apply to different people. So you may have a non-solicitation with for your customers not to be solicited, for your referral sources is even something that's protectable in Florida, for your employees not to be solicited. There's a number of different ways to have non-solicitation agreements, but that is a separate type of clause from a non-competition agreement. You can also have non-disclosure agreements, protecting your information by itself, and separate provisions for returning company property, and things of that nature. Go to the next slide, please. So the strict non-compete is trying to stop somebody from doing the same type of business that you do. And I'll tell you from my experience, it is much harder to convince a judge to enforce a non-compete than it is a non-solicitation agreement. Trying to stop somebody from working in general in their chosen field is what you're attempting to do. And it is possible, but there's a lot of hoops that you have to jump through. So one of those hoops is making sure you have a really good non-competition agreement, but you also need to focus on what it is you're trying to protect and where you're trying to have those protections. So you can see some of these components of restrictive covenants in general. They do continue to be enforceable after the employee leaves your company, even after they're terminated or if they've quit. We can go to the next slide, Michelle. So there's three basic things for enforceability for restrictive covenants that a court's going to look at. They're going to look at how long does it last after employment. And just as a side note, there's different kinds of restrictive covenants. There's also restrictive covenants that apply to the sale of a business. But we're really focused here on employment and post-employment restrictive covenants. And so in addition to how long the enforceability is, courts also look at the territory, what area is being protected, and what scope of activity is being protected. Like I said, the true non-compete is the one that gets the most scrutiny. It can be a lot easier to enforce non-solicitation agreements, especially if the person really deals with solicitation. So if you have a non-solicitation of your customers, if you have a salesperson that leaves and they had a non-solicitation agreement, that's much easier to show that they were directly involved based on their work. They had access to your information. That's a really important part of what you're protecting. That's what you can protect with a non-solicitation as it applies to employees. Non-disclosure agreements are largely enforceable across the country, even in states like California. Statutes and common law, they protect companies from having their business information stolen. But there's some specifics that go along with it that we'll get into in more detail. In order to have a contract, you're probably aware that you need to have consideration. You give one thing, the other person gives something else in return of value, and continuing to employ somebody is considered sufficient consideration in Florida. So whether that's the beginning of employment, in the middle of employment, whenever you give them the agreement, your promise to continue to employ them, even though it's at will and can still be separated, that promise can constitute sufficient consideration. Another area to consider, which probably applies in most cases, the confidential business information that you have. If you're allowing the employee access to that information, that can also be consideration for entering into these types of agreements. All right, Michelle, next slide, please. So enforceability of restrictive covenants. I'm sure you've heard, because I know I have, that these things are not worth paper they're written on, right? Paper they're written on. That's not true. That's a myth. And it's maybe more true in other states than others, but certainly not in Florida. In Florida, we have a specific statute that applies to restrictive covenants. and it tells you what you need to have in your agreement. And if you comply with that statute, your agreement is enforceable. Sometimes it can be difficult to convince a judge to comply with the Florida statute. Sometimes you have to appeal your case to a different court, but it's laid out very specifically how long the agreements can be, and what you need to have in there for it to be enforceable, to be protectable. So these are some of the general components, and they have to be in writing, they have to be reasonable, consideration, legitimate business interests. Some of those legitimate business interests are actually listed in the Florida statute. Your customer relationships, your confidential information, and we're fortunate because the statute is not an exhaustive list. There may be other things that you're trying to protect beyond the statute, but they do give some examples. So some of these bullets here are more in general. Being part of an employment contract, there is a requirement to have it be in writing, but you don't necessarily have to have an employment agreement for a restrictive covenant to be enforceable in Florida. Similarly, you don't have to take into consideration fairness or really even public policy. There's a general presumption in the Florida statute that an employee's ability to get a job or the public policy of enforcing restrictive covenants is in favor of their enforceability. So there's some rebuttable presumptions that a person can overcome, perhaps with respect to fairness, but generally speaking, a business is starting from a position that these agreements are enforceable, they are fair to protect the business interests, and as long as they comply with these other components of reasonableness and protecting specific business interests. In addition to the Florida statute that I keep mentioning, there's also a number of other laws that affect this area. There are a number of anti-theft statutes. So Florida has some, the federal law has some, there's trade secret laws, state trade secret law, federal Defend Trade Secrets Act, and we'll talk about that a little more. There's also some computer laws. So if somebody is exceeding their authority on your computer system and copying all your documents, even while they're still employed, there is a potential that they can be sued on that basis. So when you consider all these things together, your strongest position is to have a well-drafted restrictive covenant. If you want to protect solicitation, have that in there. If you want to protect non-competition, have that in there, non-disclosure agreements. But if you don't have that agreement now and somebody steals your confidential information, there still may be avenues of enforcement that are available to businesses. We'll go to the next slide, please. So here's an example of certain types of employees that you may want to consider having sign a restrictive covenant. And we would certainly recommend not having everybody sign one because not everybody has access to your protectable interests. So somebody who does physical labor for your business is most likely you're not going to be able to enforce restrictive covenants against them, certainly not non-competition or non-solicitation. We talk about the janitors is a good example. Unless you're not going to be able to enforce those kind of agreements. You would be able to enforce your confidentiality if somebody steals your stuff again, but not from just going down the street and doing the same kind of physical labor. Anybody have any questions on that before I move on to the next slide? No? Okay, we'll go to the next one. So as far as time goes, the Florida statute says that anything under 6 months is considered reasonable and anything over 2 years is considered unreasonable. So the most generic way to draft a non-compete is to go up to that 2-year limit in Florida. You can't compete for up to 2 years. You can't solicit our customers for up to 2 years. I would recommend considering a shorter period of time to increase your chances of enforceability. You have to remember sometimes information will go stale, whatever kind of confidential information, if they have your pricing, they have your customer contacts, that stuff's not going to last indefinitely. Stuff changes over time. So if you can narrow it down, it helps when presenting to a judge and how reasonable you're being. You have a narrow scope. It's less than the statutory maximum as to time. That is certainly something to consider. I would recommend considering that. When it comes to territory, there has been a trend for businesses to state that their territory is national. It's real easy with, especially any kind of online business, when you're selling in all 50 states. Florida will enforce a national territory. Florida will enforce a worldwide territory. But I would say go into greater detail and discussion about what your actual territory is. Maybe it's the state of Florida, but maybe it's the Tri-County area. Maybe you want to look at certainly where you have offices, where business is done, where this particular employee is operating, and try to keep it as narrow as possible. If you're not doing business with anybody in Georgia and your agreement is limited to the state of Florida, the employee goes to Georgia, they're not going to be competing with you. They're going to be going after customers that are outside of your territory. And again, the more limited it is, the more helpful it is for enforcement. Next slide, please. So this discussion is probably more appropriate in other states. Some states have a specific requirement that your agreement is only limited to the employee doing the exact same type of work for a competitor. Substantially similar activities is another, like in Georgia, that's the standard that they have. We don't have that particular standard in Florida. So if somebody is a marketing director for you and they go to be an operations director at your competitor, you can still have enforceability. But I would recommend taking a look at what the employee does and what it is you're trying to protect. A lot of times we'll talk about the janitor rule. They can't go to my competitor and pretend to have a different job title and say they're a janitor because they have all my trade secrets and they're taking them with them. You want to look at what will be damaging to your business if this person leaves. If they're a salesperson, any kind of sales type of role, any kind of interactions with customers, any kind of discussion about the product. It can be pretty broad in terms of what you're protecting. It's pretty common to use language of the employee just can't go work for a competitor that performs substantially the same thing as your company. So you're defining the competitive services of the business rather than the competitive services of the individual employee. You certainly want to discuss what your business does and how you're protecting that against a competitor, but you may want to consider having it a little more narrowly tailored towards that employee in particular. So like I said, in any capacity is generally overbroad, but you can get away with, you have a little more leeway in our state in terms of what you can protect. Next slide, please. So here's a number of drafting considerations for your agreements, the agreements you're going to have for your business. And we've already discussed some of the state requirements in Florida. There are certain employees who may be exempt from non-competes. We don't have a lot of exemptions in this state. There was a recently passed one that deals with doctors, medical doctors. If they're in a rural area where there's not a lot of, there's no other medical provider who does the same exact thing. It's a very narrow exception, but something to consider. Like I said, the Florida statute is very pro-enforcement. So if you're trying to protect your business interests and you're in multiple states, you'd rather be here than anywhere else. One of the things that one of the overall things that you want to think about with your agreement is what are you trying to protect? And the way I always say it when it comes to a lawsuit is what's your secret sauce? What do you do that's different than your other businesses? What gives you the competitive advantage in the market that you're trying to protect? And I know Ari and I hypothetically had a lawsuit where the business, they dealt with public entities in an open bidding process in some respect, but they also had what was called sole source agreements. So they were they had a contractual right to provide these particular parts to municipal entities, and they had defecting employees that solicited those customers and tried to move in on those sole source agreements. And so when we were in this lawsuit in particular, we asked the court for an injunction and asked for a hearing so that we could present our evidence. And before we even had the hearing, the judge entered a restraining order saying these sole source agreements are coming up for their renewal date within weeks. and you have evidence of these people stealing, and I want to preserve the status quo until we can hear what's going on. Does that sound right, Ari? Is that our case?
Yeah, absolutely. In fact, these are the types of cases where an ounce of prevention is really worth a pound of cure. Because, for example, when you go to court and you want to ask a court to stop the employees, to enter an immediate order to stop your employees from doing what they're doing, taking your customers and your, great business contracts that you've worked so hard to establish, you're going to need to bring in some proof. If all your employees have access to the same database with the same password, how are you going to prove that employee A was the one that accessed it beyond, after hours, after he was terminated? You're going to need to do whatever it takes on the front end, not only to have the right agreements in place, to understand what really are your most protectable interests, how to protect them, but also how to prove any access or theft or use of that information after the fact. So protecting your data, who has access to that data, well-drawn contracts in advance. As David mentioned, you do have these other common laws and statutes that protect your trade secrets outside of an agreement, but you need to have the knowledge in place of how those laws read so that you can have the mechanisms in place to prove those cases in order to be able to run to court and get a court to want to help you out. So like I said, an ounce of prevention here is really worth a pound of cure. These are very acrimonious cases and very expensive because obviously, you had somebody, you take them in, you took them under your wing, you taught them everything you knew, you probably treated them really well as an employer, and then they run off with your information. So they get really ugly and really expensive. And if you do a lot on the front end, you make it easier for yourself on the back end.
Yeah, and let me make a point about one of these bullets I think is really important. What should your agreement look like? Should it be standalone? It's pretty common to include non-compete or non-solicit provisions within other agreements, within an offer letter. But I would recommend having them be standalone. And one of the biggest mistakes I've seen company make is sticking it in their handbook. And that is not going to be enforceable. A handbook for an at-will employee is not a contract. It can be changed at any time. So that means that even your restrictive covenants that are in your handbook are considered not enforceable. So don't make that mistake. Definitely get some guidance. If you have an agreement that's in your handbook now, you're going to want to separate it and have it re-signed. All right, we'll go to the next slide. So some other protectable interests, goodwill. This means if your business has been in the community for a long time, and people know your name, they know your business, and they associate your employees with that name and that goodwill. It can be a particular trademark or something like that, but it could just be your reputation. There's trade secrets in particular, and those are very particular. We'll talk about those in more detail. Confidential information is really broad, but like Ari said, the more you try to protect your information, the more it'll be treated as confidential, right? So if it's not posted on your company website, your external website, you're going to be in a lot better position to say that it's confidential. Whereas if it's published to the public, it's in a very difficult position to now say that that's your confidential or unique information. The choice of law, that's what I was discussing, where if you have multi-state operations, pick Florida law as the law that applies, and try to have a form selection clause. Means where's this lawsuit going to be brought? You want it brought in Florida if you can. That is your best jurisdiction, in my opinion. Next slide, please. So these are just some other considerations we've already discussed a little bit in time and geography. When it comes to arbitration, you'll probably get as many different opinions as different lawyers that you talk to. I am not a fan of arbitration. The pros are supposed to be that it moves faster, it's cheaper, and you avoid a jury verdict. The cons can be, I don't think it's really any faster. I think it's full litigation. She knows it's full litigation. It can be a fight over just getting into arbitration, and that can cost money. You do avoid a jury trial. That is a huge benefit, but you can also have jury trial waivers in your restrictive covenant, in standard employment documents. So you can contract for the benefits of arbitration without having to go through the difficulties of arbitration, my opinion. But there are a lot of lawyers who love arbitration agreements and try to get companies to use them heavily. So certainly something to consider.
Yeah, if you really have an arbitration ruling go sideways on you, the appeal options are extremely limited. You basically have to show misconduct on the fact that the arbitrator can get the law wrong, and chances are you don't really have any real appellate. So it's kind of it's fine, and it does tend to be just as expensive. And then the first fight often you have is whether you should even be in arbitration. That's how the other side makes it really expensive for you. Is this agreement enforceable? Oh, I never signed that. There's always a fight, or I said maybe 8 times out of 10. The first fight is whether you should even be in arbitration, which drags it out and is expensive. So you have to be really mindful about whether you want to enforce the arbitration or even have an arbitration agreement to begin with. Like David said, you can try to put in as many of the benefits of arbitration as possible into your agreements without forcing everybody to arbitrate. Also, there's a movement against mandatory arbitration in general in employment law cases that we're trying to work with here. But thankfully, we're still in Florida where the public policy still favors arbitration.
No, but that's a good point. There's individuals will bring public pressure on businesses. Even law firms have been singled out for having required arbitration clauses, and they just get bad press from it. But and I agree, our arbitrators, they're on the private sector. They want to be hired by both attorneys in the future. So they often split the baby with their decisions, which is not what you want. For these other bullets, assignability, it's pretty standard in contracts, but make sure you have it because your business name may change, your corporate structure may change, you may sell these assets to somebody. It's important for these things to continue their enforceability, even if the corporation changes over time.
I do have a question.
Sure.
Actually, a couple questions. On the previous slide, there was something that stated who is exempt from non-compete agreement. First of all, what type of an employee or partnership would be exempt from a non-compete? And in the situation, I know we're talking a lot about Florida law. Do these laws differ, or is it easy to translate them to a national brand where I have multiple locations in multiple states and I'm trying to enforce these all around, say a franchise, for example? Is that easy to do, or does the law get a lot more complicated in that area?
So those are two great questions. I'll start with the first. What employees are exempt from non-competes? Generally speaking, almost nobody. They can apply to almost everybody. If you can meet the standard requirements of you have a protectable business interest, it's reasonable to time and that kind of stuff. There's no, it's not like engineers are singled out or something like that. They can apply to any type of position. The only specific statutory exemption in Florida that I'm aware of is that medical one, that applies in very rare circumstances. But the flip side of that,
that's just for rural areas.
Yes,
if I heard
that's
you
right.
correctly. Okay.
Yeah. And I know you were telling me about your business that most likely wouldn't apply anywhere because it's county-wide. It would have to be the entire county doesn't have somebody that does what you do.
Gotcha.
Then you might not be able to enforce it.
Okay.
Lawyers are also generally exempt from non-competes in terms of public policy. And you might get an employee who makes the argument that he does something that's so important for the public good that they should be exempt from a non-compete. And then also the question of, you have people that are, independent contractors, and maybe you call employees, and in some circumstance, part of what makes an independent contractor and not your employee is the fact that he can go work for other people. So that's when you don't want a general non-compete in place. You want something that's much more targeted to your own data, non-disclosures, and then obviously you have the common law protections or the statutory protections that do protect you for, if somebody runs off with your trade secrets. But, that there's a distinction, and David can speak to that a little bit more as to, how you can target certain types of employees. And then if you have independent contractors, a non-compete agreement might not fly because otherwise that person isn't your independent contractor.
That's right. And just to fall off that real quick, there are certain circumstances where you can have restrictive covenants with your independent contractors. But we could discuss that later. What other states do with respect to who can be exempt from a non-compete is they'll put a threshold. So they'll say somebody who is exempt under the Fair Labor Standards Act, somebody you pay a salary to, like a manager, those people can have non-competes. But if they're not exempt, people you pay, hourly employees, you can't have a non-compete with them. Or if they make under $50,000 a year, they can't have a non-compete. A lot of states are passing these kind of laws where it's more and more difficult to have non-competition agreements. So your second question is a little more complex, but to sum it up, yes, you can have a national strategy. And if you are based in Florida or have heavy operations in Florida, my suggestion would be to have a Florida-based agreement. And then there's a number of other states that will just enforce Florida law. If the person has some kind of connection to Florida, they did some training here, they came to the state once or something like that, you can often have it either enforced in the state of Florida, or let's say they're in the state of, I'm trying to think of a good example, Texas. Texas you can go into court into Texas and they will apply Florida law. So you have consistency within your business in terms of what's enforceable and what your contracts look like. The problem is there are some states that are very restrictive, and those number of states are growing. So in states where they say, we'll enforce another state's law, but only if they abide by our public policy, then you're going to have, the way I do it is I'll have an addendum on the agreement. This is the Georgia addendum. So where it normally says the employee can't do any competitive activities, now in Georgia, it'll say the employee can't do any substantially similar activities for a business. So what we'll do is for those states where there are those specific requirements, we carve out what's required to modify your Florida-based agreement, making as few changes as possible to comply with that state. The third part of the process is fallout states that you just can't have any kind of enforcement. California, you can't have non-competition agreements. Massachusetts is now super difficult. So we'll have a standalone confidentiality agreement, non-disclosure agreement for those states. So that's one way, and I think that the simplest way to have a national strategy. Other ways, you have a different agreement for every single state because it's driven by state law. And some states have very particular requirements. But no, that was a great question.
Thank you.
All right, let's see. So yeah, these are some examples of other things that can be in a restrictive covenant besides the non-competition, the non-solicitation clause. And when you have an employee non-solicitation, you want to identify who an employee is. Because if you say anybody who's a current employee, well, if the person quits and then the next day goes to work with this person who had the agreement not to solicit, they can say, I wasn't a current employee, I'm a former employee. So you want to define somebody who's worked here within the last 6 months or worked there while you worked there. There's different ways to do that, but be aware of that. Florida statute does specifically allow you to have restrictions with your independent contractors. It's most common for your confidential information. We have somebody come in and work as a contractor. We don't want them to steal our information and go somewhere else with it. But you can also protect them from soliciting your customers and cut out the middleman, take you out and start their own business going after the same people. There certainly are protections there, but I think Ari pointed out a good caveat that if you have a strict non-compete with a contractor, a court may say, well, is this person really a contractor? Are they on the market? Can they work for other businesses? Maybe they're really your employee. And now you have some wage and hour concerns. Were you paying them a proper salary? Were you paying them overtime? That can be the hole you fall into with independent contractors. Some other types of agreements like garden leave and golden handcuffs, it talks about basically paying somebody to stay out of the market. We'll give you a year's salary. You agree not to compete for a year. And a lot of times you can put your restrictive covenants in a severance agreement. So you didn't have an agreement before. Now you're exiting somebody. We'll pay you 6 months of severance. You agree not to compete and you pay that out over time is the smartest way so that if you come across a problem, you stop the payments.
There are
So-
some considerations. I'd like to jump in on
Sure.
separation or severance agreements. There are some considerations when you're drafting. If you're separating an employee, sometimes the agreement itself will say, this is the only agreement between the parties. All prior agreements are not valid, la, la, la. All of a sudden, you've just contracted yourself technically out of your non-compete. So make sure that if you're doing any separation agreements, that you contemplate the agreements you want, that you have in place, that you want to bind your employees to. And there was one more point, but it'll come back to me as soon as I remember.
Oh, that was a really good point. Yeah, just jump right in if you think about it.
Okay.
So I, hypothetically speaking, had a lawsuit recently where the employee had a non-solicitation agreement. It was really a non-disclosure agreement. It wasn't a very good agreement, but I was stuck with it. And the employee left and went to work for one of my client's customers during an ongoing contract. And he interfered with that contract. He told the customer, they're not doing a great job, they're overcharging on this. And we were in a tough spot because we didn't have non-competition. We didn't have a good customer non-solicit provision, but we did have the non-disclosure. And so he took information with him, and we found out about it. He sent himself a lot of emails, copied a whole bunch of documents onto a drive on his way out the door. And so we were able to kind of shoehorn in restrictions against him that he was violating and interfering with ongoing contracts. So, and I'll talk about that in a little more detail, but you definitely want to do a little digging on employees who are leaving to see what they're doing on their way out the door.
I remembered what I was going to say. Also, you have to think of what defenses this employee might have to enforcement of your non-compete. For example, you had somebody who was in a management position that did have access to your information. And let's say that information is still, hasn't gone stale, is still, in this person's head or in their documents or whatever. Let's say you transfer the employee to another position. Is that new position going to be subject to the same non-compete? Oftentimes what happens is an employee will say, well, you failed to pay me my bonuses, my wages, my this, my that. And that way, therefore you can't hold me to my non-competes because you breached an underlying, contemplated term of that employment that you weren't going to change my compensation, lower my pay, or whatever. So whenever your employees move from one position to the next, you're going to have to contemplate the fact that you have these restrictive covenants and the access in place, and they might have access to new information that they didn't have to before, new territories or new customers. And then by the same token, they can say, well, circumstances changed. I signed that non-compete under this set of facts and this set of compensation. And now, you breached that. So when you're moving employees from one situation to the next, you're going to have to look at what you have in place, as a best practice.
Yeah, and that's a really important point. So I want to reiterate in case anyone missed it. One of the strongest defenses against enforcement of a non-compete is failure to pay wages or commissions. So an at-will employee, they may not have a formal employment agreement for a term, but you do have a contract, you have an oral contract with the business. I agree to work, you agree to pay me. I did the work. So if you didn't pay me, you breached the agreement first. Now I don't have to honor your restrictive covenants. So if you're trying to enforce, you want to make sure that you've paid out everything that is required under any kind of commission plan or wages. If you are seeking to avoid enforcement, that is the first place that you should look. I had a business that started and a former business tried to sue them. So I was on the defense side. And we were unfortunately in a position where the principals did take a number of documents on the way out the door. They did not have a non-compete agreement for the key employees, but in this type of business, they were it was a construction type business, and they were bidding for projects in the open market on the open bid process. So without a non-compete agreement, they were allowed to participate in that kind of process, and that kept us from getting an injunction against us. But that didn't end the lawsuit. Taking the documents is a difficult thing. So if you're thinking about starting your own business, you cannot steal from your current employer. That a judge will throw the book at you. That is the easiest way to get enjoined. And that's typically the way we go about it, getting injunctions against former employees. A strict non-compete by itself can be difficult, but taking documents it's a lot easier to convince a judge that the person stealing and should be sanctioned.
And using the time while you're at your current employer to start setting up your other business, the time, money, resources, efforts, all that is enforceable. But of course, a lot harder to prove. And you should, you should do everything you can to document what you give this employee access to.
Yep. Michelle, can we go to the next slide? Or Kelly, I forgot who was doing it, sorry. Okay, so Aria touched on these kind of things that you need to do in order to keep your information confidential. These are things you absolutely must do for something to be considered a trade secret. But you certainly need to do some of these things for your documents to be considered, your information to be considered confidential. Having computer passwords that are individual to people, having policies and procedures saying you can't take this stuff outside of work, or it can only be used for business purposes. Limit access, so not everyone has the same access to servers and folders. In the old days, we'd say don't leave the papers out on the shelf. Put them in under lock and key, and everything's electronic now, so that's the way you need to go about it. And having written agreements with employees who have access to this. That's another form of protecting your information. We go to the next slide. So this has some discussion about social media and monitoring. The one thing that I want to say about this that's a good takeaway is make sure your employees know that when they're on company equipment, that their communications and anything that they're doing can be monitored. I had a circumstance, listen to this. So tell me what you would do. The employee complained to the owner of the business that she was being sexually harassed by her manager. The owner said, okay, I'll look into it. Goes on her computer to see the emails between the manager and her to see if he can find some corroboration to see how he's talking to her. Sees on her computer that she is sending the company's trade secrets and confidential information to a competitor. Can you act on that information? Well, so
No.
I think, yes, I think they're two separate issues. Judge might see it as two separate issues, or you could distinguish that it's two separate issues. So that I would document moving forward on the sexual harassment, but I would also document moving forward and have a strategic plan on sharing the confidential information.
yeah, that's a really good suggestion, Michelle. And I'll tell you a complicating factor that I had. It wasn't just that the owner was on the company work computer and looking at work email. The employee had her Gmail open. And it wasn't just on the screen where he could see it. He started clicking through her emails. He went through her inbox and scrolling through them on her private email. But it just happened to be logged into her computer. So the reason that's a problem in Florida, there's a constitutional right to privacy. And there is a little bit, but there is some case law that says if you're wading through somebody's inbox in that kind of circumstance, that you're invading their privacy. That's not going just through your company equipment or your company email that was available. And then the second complicating factor was the employer did not finish the sexual harassment investigation. He called her and fired her right there. So we dealt with the sexual harassment lawsuit, not the enforcement of the non-compete part.
So my question, I guess, in regards to that is, so if someone's utilizing company property, say a company laptop or computer, to access information that's personal, if it's not spelled out specifically in your communications policy or procedure, I guess, would that still be an invasion of their privacy by me, the employer, looking at that Gmail account, I guess?
I would say usually not. If an employee is using your computer system, your company computer system, and clicking on websites and your server tracks those websites, or they're sending work emails across your work server, they don't have an expectation of privacy in those things, and you can monitor that without issue. If they click on their personal Gmail and it loads up on the page, and your server grabs that screen, again, that's not something that they have a right to privacy or an expectation of privacy. We would recommend that you have a policy that says anything you do on a company equipment or on a company server is subject to being monitored. The very small exception that I was talking about in this particular circumstance was somebody who left their password signed in to one of their accounts, and the person just started scrolling through and reading everything that had not already been opened on the computer. So that's a very particular, small exception, I would say. Yeah, the most important thing is just letting employees know that they can be monitored. Same thing when you hear with the telephone call. I mean, there's a wiretap law in Florida, but you hear customer service says this call may be monitored, recorded and monitored for whatever protections. It's letting you know so they're not surreptitiously recording you. It's just putting somebody on notice that they could be recorded. All right, we'll go to the next slide. Michelle, you can actually skip one more. So this is a common definition of what a trade secret is, and this can be the most challenging part about litigation or protection of confidential information, because a trade secret has a particular definition, and it's over and above something that you just consider proprietary or confidential. It's something that you put under lock and key. It's the formula to Coca-Cola. And a lot of businesses think that everything they do, all their sales techniques that they invented are considered trade secrets. They might be, but they might not be, depending on how they're treated by the business. So certainly not something that's publicly available. There's something that you can Google, or we used to say if you can look it up in the phone book, the phone numbers for your contact people, the people that you sell to, would not be trade secrets. It's possible that you have culled a system, a database that has contact information and sales history and these kind of things. That stuff might be protectable. So that's why it's important to treat those things confidentially. Go to the next slide. So these are some examples of what could be trade secrets, depending on how they're treated. I did have litigation dealing with employees who they learned they were a type of engineer, but what the company did wasn't something that they learned in school. The employees learned a very highly technical, specific process at the company. And so when they left and went to a competitor, we were actually trying to enforce a real strict non-compete doing the same thing for another business, but also we did focus on the trade secrets aspect, just because of how particular and technical it was. It wasn't something you could just learn on the street, and it wasn't something that you could just Google. And just because the training that you provide to your employees is expensive, doesn't mean that it's a trade secret. So that's a consideration. It might be a factor, but just because there's a cost involved doesn't automatically turn it into something that only your business does. Go to the next slide, please. And skip one more. So there's lots of different ways and how information can be taken. And I know, Matt, you wanted to chime in with some recent experience on trade secret theft.
Sure. So yeah, we had a recent case where there was a former employee of a company, and there was an Instagram post posted by the competitor's owner, showing the former employee at a cocktail hour Zoom event. So the company was surprised by that because the employee actually had a non-compete agreement that prevented her from going to work for any competitive business, and this business happened to be like the company's biggest competitor. So the company went ahead and had their IT people do a search on her work laptop that she had returned right after she left the company, and they were able to ascertain that while she was employed, she had a offer letter sent to her work email from this competitor. She accepted employment while she was still working with the company, and she had inserted a USB device in her work laptop and took with her over 1,000 documents that had customer lists, price lists, contact information of their customers and vendors, and also had their business plans for the next year, for their marketing plans. So And the company is based in California, and the company she left was in Florida. So she had plans to actually move to California with this USB device with all their business plan for the next year. So we were able to enforce the non-compete agreement, and she also had a non-disclosure agreement which prevented her from taking these documents. And the court entered a injunction order that now she's not allowed to work with the company. She has to return all documents that she took. So you can see how things happen when an employee does this, and the courts do enforce these agreements very, very strongly.
David and Matt had practically served her as she was packed up and ready to move out of town. So they caught her just in time. And normally what happens when we get one of these cases is one of the first fights we get is how much information do we have to show the court to order an immediate action so that we can take their computers and image them and do whatever, which is a costly endeavor to begin with. So you definitely don't want to go on a costly fishing expedition unless you have the things, and I keep harping on this, the things in place to give you the proof that you need. And the fact that we were able to show in that case that this employee had put in a USB device, it just already showed that our client had a sophisticated, IT and structure in place to capture that kind of stuff.
And I'll say you don't even need a sophisticated IT, because even smart employees who are leaving can be lazy. And it's so common for people to email themselves contact information, documents that they worked today. I want to take my work product with me. I don't feel like doing anything difficult, so I'm just going to email it to myself. And so you look at the sent box from their last day. There's not even any plan. It's not even like a month before. And so that's the easiest place to start. Look at the sent and deleted mail from the last few months. Look to see if it looks like there was mass deletion. Oh, there's nothing in the inbox for the past year. That's really strange. You don't even need a sophisticated an IT department to look to see if a USB drive was inserted, but that certainly can be the next step. And I'll tell you, in this circumstance, if the employee had just left and didn't copy all these documents and do mass deletion of emails, the company might not have cared. It's sort of the conduct on the way out the door can dictate whether there's going to be litigation or not. So, you want to look at kind of both sides of the coin there. Go to the next slide, please. So the Defend Trade Secrets Act is the federal law that is relatively recent, and there's a provision that you can put in your agreements to help with enforceability and get attorney's fees under this. But the main thing is you have the avenue to go into federal court if somebody steals your trade secrets. Now, like I said, trade secret is a much higher level than just confidential information. So you have to weigh that, but it gives you another avenue to pursue someone that wasn't available before. We'll go to the next slide. And the next one, please. So when you learn that an employee has defected and stolen your confidential information, like Ari said, it's very emotional. It's a business divorce, and it's the closest thing that we deal with to family law. But you want to make sure that you're making a decision that's rational, that's not based on emotion, that will protect your business and has certain business goals. So you want to go to the next slide, please. So again, what is it you're trying to protect? What is it going to cost the company if you allow this employee to leave and don't pursue enforcement? I had a case where the company had really good non-compete, non-solicit agreements, and 7 employees left, including the CEO, and they didn't take any documents. They didn't email themselves anything. They didn't copy anything. And they went and started a competing business right down the street. So we were looking at having to enforce a strict non-compete, and we didn't have any proof of them taking customers. And so, the questions I asked of the business, well, what's it going to be worth to you? How much business are you going to lose if they keep competing with you? And one of their biggest concerns was employees would keep leaving and competing. They said it happened to them a number of times over the decades, and they wanted it to stop. So we sued the business, and rather than move for an injunction right away, which is usually the key component of this kind of litigation, we let discovery unfold because we didn't have any evidence of them stealing anything. We just knew or pretty much assumed really that they were doing a competitive business down the street. No more employees left after that point. So that business goal was achieved. And it took a few months of litigation, but the cost of engaging in that and the difficulties of starting a new business, they went under. And none of those 7 people could work there anymore and compete. So we achieved business goal number 2. We stopped employees defecting, we stopped the competition. Sometimes business goal number 3 is kind of recoup your losses, try to get your attorney's fees back. It's expensive to be involved in a lawsuit. We didn't achieve that goal. So that was the business cost. Are you willing to pay this money that you may never get back to stop employees from defecting, stop employees from taking your confidential information and using it against you, and stop unfair competition is what it was.
And often we send a cease and desist letter and get great success, but that's only if we already have, a good enough case that somebody on the other side, let's say, an employee leaves to go to another company and that legal department will say, whoa, this is a great non-compete. It's obvious. We hired them to this position. They didn't disclose the fact that they didn't have a non-compete. So that other company will say, I don't want any part of this. I'm not using your trade secrets. I'm going to terminate the employee. But that's assuming you already have something in place. Oftentimes these cases start and end with a cease and desist letter, sometimes good, and sometimes because you as an employer realize this is going to be way too expensive to pursue and way too hard to prove and way too acrimonious that I don't need the stress. But oftentimes we can get some results with a cease and desist letter.
And you can go to the next slide, Michelle. I'll tell you that there's often a defense, well, you let 5 other employees go and didn't enforce it, so you can't enforce it against me now. In Florida, that actually doesn't hold up. You can enforce even if you had not enforced before. So I would say you want to pick and choose your battles, right? If you're going to draw a line in the sand, make sure it's one that you have a good evidence on, you have a good case on, because it's going to be expensive and you want to make sure it's worth it and you get good results. Okay, you can go to the next slide.
I just wanted to share, it is 10 o'clock.
Yeah.
The time went very fast, in my humble opinion, because it's so interesting and there's so much value in this information. So I'm gonna leave it up to David and his team. How much longer do you feel like you would want to give a thorough ending?
I could say 2 or 3 more things, and then
Okay.
I can open it up for more questions.
All
Can you jump to slide 27?
Sure.
I think I've said it 2 or 3 times, so you can see that this is important. Top point, cost of litigation. It is expensive to sue somebody. You may have the opportunity to get attorney's fees based on your agreement or statute, but the person might be out of business. You might never ever get the money back. So you have to weigh whether it's worth it to do that. Next slide, please. And these kind of non-compete lawsuits move fast. So more of the litigation is up front, whereas with a normal, say, discrimination lawsuit that we deal with, the trial at the end is the big part. This is everything happens early on. And you can skip ahead to slide 33. I had talked about the things that you want to look for in the sent box, the deletion. Also look for evidence that the person was using a cloud service. Sometimes you get a confirmation email, oh, you signed into box.com or Dropbox. That's another way to see somebody was copying your documents. There's also, Ari had mentioned, can you skip ahead to slide 36, please? So one of the reasons we send a cease and desist is we can say, we've definitely put the employee on notice that they had these restrictions, that we're aware, or we have some assumptions about their conduct, but sometimes you want to send that letter to their new employer, so now they're aware that the employee had a contract and of the conduct we believe is happening. So if they don't fire the employee, you can sue that new business for interfering with your contract. That's the step that needs to happen to make sure that they are for sure, certainly on notice. And that's the next step. So that's the main takeaway. Everybody will get these slides for the sensitive information, but are there any questions on this that anybody had that we didn't raise while we were going through?
Will you guys be providing, I've been taking some notes here, but will you guys be providing a copy of this PowerPoint?
Yes.
Okay, good.
Also, Robert, just keep in mind that we are recording this and it will be archived on the chamber website. So if you want to go back in and listen to it, you know, again, because it really was a tremendous amount of information. Thank you so much, everyone.
Thank you so much for taking the time to hang out with us for an hour virtually. I like this topic. I think it's exciting.
So I have a question. So I operate a virtual company where everyone works out of their home offices. They use their personal devices on a cloud platform. What type of protections should I put in place beyond a non-disclosure confidentiality agreements and non-compete agreements to protect that type of operation?
That's a good question. Some of the other things you can do besides the agreement is to, if you don't already have these policies in place, make sure you have policies that your business information is only to be used for your business purposes. Discuss that having your policies that employees need to return everything, what they can do and what they can't do with respect to the cloud services. If you only have one cloud service that you allow, you can specify that. And in this way, you can point to, you have policies and procedures that say the employee can't exceed this level of authority that you've provided to them. And if they do, not only have they breached their agreement, they violated your policies. That's one of the additional protections that you can have.
Thanks.
Any other questions from guests? No? Okay. I did want to share with our guests on the call that FordHarrison and in particular this group of speakers here today, they are the only group at the chamber that does a quarterly webinar as part of a series under the head of employment law. So each quarter they do have a webinar. So when I send an email thanking you for joining today, I will send the date, the topic of the next webinar. So they do 4 a year to make sure you guys have it. And they're already all 4. Actually, I'll send all 4. They're all up and running. You can register for them on our website, but I'll make sure I send the links for you to register if you're interested. Okay. All right. Well, I want to thank my colleagues, Kelly and Kirby, for helping me with the technical aspect of this. And we always have a couple people on these calls to make sure things go smoothly. And I especially want to thank David, like we said, is a board member here at the chamber, and for his leadership and for taking the time to share this information, and his colleagues, Ari and Matt. Thank you guys so much. These are always interesting. I always wish we had more time personally. So we thank you for sharing your time with us. I know all attorneys are especially busy right now, but I know you guys in particular are busy. So thank you very much for sharing your time with us today.
Thank you.
Thank you.
All right. So I hope everyone has a safe and productive day today. Thank you.
Thanks.
Bye, everybody. Thank you.
Bye.
Bye.